Welcome today to our Conducting Effective Investigations webinar that's been facilitated by Nathan Andrews from Fretton's Solicitors. My name's Jo Thompson and I'm a consultant for HR Recruit. I'm joined today by Nathan, who will introduce himself shortly. Nathan is going to be drawing on his professional experiences of conducting complex workplace investigations to share tips and best practice. If you've got any burning questions during the session, then please put them into the chat box facility and we will cover them at the end. I'm now going to hand you over to Nathan, who will introduce himself and start the webinar. Thank you.
Thanks, Jo. Hello, everyone. Good afternoon. As Jo has said, my name is Nathan Andrews. I'm the Head of HR Services at Fretton's Solicitors, and today I'm going to be talking to you about conducting investigations for effective outcomes. Just to advise you all that obviously everything we discuss today shouldn't be considered legal advice. If you have got specific workplace issues that you are dealing with, we always recommend you seek professional advice if there is anything you're unclear about. So don't consider anything we discuss today as legal advice. It is knowledge sharing in a more general sense, because obviously I have no knowledge of any particular issues you may or may not be dealing with within your own organisations. So my role at Fretton's, as I've said, is the Head of HR Services. So I look after the HR consultancy services we provide to our clients. Part of the work that I do within the firm is around handling complex workplace investigations. So I'm a trained investigator. I'm also a trained and experienced HR practitioner who specialises in employee relations management for the last 20 years. So we'll be drawing on my professional experiences to hopefully bring some of this knowledge to life in a practical sense for you all. We will be covering questions at the end of the session, so if you have questions, please use the chat box facility. I know, Jo, you're going to monitor those for me, aren't you, in the usual way? Amazing.
Yeah.
Okay, so what I want to do, Jo, just let me know for the purposes of the webinar if you can see my slides moving.
Yep, can see them.
Perfect. So just what I want to do, first of all, is to give you an overview of what we're going to be covering today. So we're going to look at launching an investigation. We're going to consider HR's role in that investigation process, how we or the investigating officer should approach the investigation process. We will talk about suspension during an investigation process, what happens if the police are involved, maintaining confidentiality, holding investigation meetings, and we'll also touch on questions for any investigation meetings that you may need to hold as part of your investigation process. So, first thing we want to talk about is launching an investigation. So I want to cover things with you around how you go about starting that process. And there are some things that we always recommend you should consider if you believe you need to conduct a workplace investigation. So it's an important point to remember, and it's something that can often be overlooked by employers, certainly with the client group that I work with, that you don't always have to conduct a full investigation if a matter is straightforward. So, depending on the situation that you are dealing with, it may be that you can have a short, very concise investigation because of the situation that you're dealing with. But if matters become more complicated, that's where you may need to consider holding a more involved investigation process that takes more time. So if an employee reports any issues, you should always first consider what options are open to you. And if you have internal policies or procedures which set out specific actions that you should take, you should follow your policies and procedures. That's an important point, especially if any policies or procedures you have in place that set out what you will and will not do when handling investigations is contractual. If you've got contractual policies, you absolutely need to follow them to avoid any breach of contract claims. Hopefully, any policy you do have will be non-contractual, which is the preferable position. But there are some points to consider. So one of the most important points that I always focus on when I'm working with clients to conduct investigations, bearing in mind the investigation work that we undertake for our clients are typically complex. They're typically dealing with very complicated issues or requiring us to speak to a wider pool of people than may be for a straightforward matter. But we always advocate that if you believe you need to conduct an investigation, you should absolutely have a clear plan for the investigation process. So your investigation plan should set out who the investigating officer will be, the terms of reference for the investigation. That's particularly important. It's certainly important for me in my role as an external party going into an organisation to conduct an investigation, but it's also really helpful if you are handling as an HR practitioner in-house an investigation regarding an employment matter, because that investigation plan and the terms of reference give you the framework for your investigation. So it should give you a framework to follow to make sure that your investigation is absolutely addressing the issues that need to be investigated and that you are gathering the relevant information. So terms of reference are really important. If you're the investigating officer, set out your terms of reference so we're all clear on what you're going to do as part of that investigation process. You should look to set out a provisional timeline. So it gives you a timeline to work towards, but it also gives other parties who are perhaps involved in this process an idea of when you are likely to conclude your investigation work. So that's really important and can be really helpful in managing, people's general well-being throughout this process. Because if you've got a party who is subject to investigation, it can be a stressful process. So giving people an expectation around timelines can be really helpful. You need to identify the relevant company policies and procedures which may apply to the matter that you may be investigating. You also need to think about issues which need to be dealt with as part of that investigation process. You want to give consideration to the types of evidence which need to be collected, and that could be witness statements, CCTV footage, copies of documentation, IT access logs, etc. So if you're used to conducting investigations, you'll know that these are some of the things that you need to consider. Apologies if you heard, that's just the internal phone system. So you'll also need to give consideration to the people who may need to be interviewed as part of the investigation process. So again, if you've got a wider pool of people that you need to meet with, that's going to take some coordination. So you just need to give that consideration as part of your plan. So we would always recommend that you identify at the outset, who do I need to speak to? That list may develop and grow as you work through the investigation process, but it's good to have at the outset a clear idea of parties that need to be spoken to and how you're going to meet with those individuals, whether you're going to do that in person or whether you're going to do that via Microsoft Teams or Zoom, as the case may be. Also take into consideration any specific arrangements that may need to be made for the meetings. It may be that you have parties that aren't able to access Microsoft Teams or Zoom, although this may be unlikely. It's something you should give consideration to. And if that's the case, you may want to arrange meetings in person. And again, it's good to have an end date in mind. So I always recommend when you're formulating an investigation plan that you have a date in mind for when you want the investigation to be completed. So start and end dates are really important. When I'm handling investigations on behalf of clients, or even when I was back in in-house HR roles, I was always very clear on when my investigation would start and when my investigation would likely end. That end date may change depending on what you uncover throughout the investigation process. So it doesn't need to be set in stone, but again, it's really helpful to give people a guideline so that they understand what to expect as you work through the process. Now, one of the things I always emphasize is that creating an investigation plan at the start may seem like an onerous process. It's often normal for people to want to get stuck in and to get started, but it is really helpful if you set out a plan that covers all of the bases that you need to take into consideration before you launch your investigation. And as I said at the start, it's a really useful framework to have in place. So it keeps you concise and focused as you work through your investigation process. So I just want to touch on HR's role in the investigation process. Now, if you are an HR practitioner on the webinar today and you are responsible for handling the investigation, and what I mean by that is that you are the appointed investigating officer, the investigation process is yours. You are responsible for the conduct of that investigation, and therefore you manage the process and you go about conducting that investigation work to establish the facts. Now, if you are not handling the investigation, but you are supporting and providing advice and guidance to an investigating officer, it's really important that we don't overstep the boundaries of our work within the HR role. Ultimately, the investigating officer is the person that is responsible for the conduct of the investigation. We should not be applying undue influence or pressure on the investigating officer to reach certain conclusions. Our role is purely limited to giving advice and guidance on policy and procedure. And this has been established in case law that HR should not be overly involved in the investigation process unless they are the party that's conducting the investigation. So I just wanted to cover that with you because I think it is an important point to consider. I know from my own experience being an in-house HR practitioner, it's sometimes quite hard not to want to guide someone and say, actually, have we considered X, Y, and Z? And that could be seen as us having, being overly involved and, shaping someone's thinking or thought process when actually we need to allow the investigating officer to manage that process and reach their own conclusions. So happy to take any questions from that at the end if you have any. So approaching the investigation process in itself. So what we want from a good investigating officer is for them to adopt the right approach, and it should be organised. It should, as we said, you should have that plan to work from. An investigation plan is particularly helpful if you've got an investigating officer who isn't an HR practitioner, so they won't necessarily have had the same training that we would have had. So giving them that plan, working with them from an HR perspective to develop that plan can be really helpful because then you can set them on their way to complete the investigation. So a good investigating officer will be thorough and considered in their approach. They certainly shouldn't adopt a, kind of a fly by the seat of your pants approach. You want the investigating officer to dedicate proper time to the investigation process, which allows them to gather evidence and to establish the facts of the case that they are investigating. So you need somebody who is not going to rush the process. They're not going to make an assumption at the outset that the person's guilty. The role of the investigating officer is purely to be the fact finder. They need to go away, establish what may or may not have taken place, as the case may be, and then they should draw their conclusions together in their investigation outcome report. As HR professionals, it's our job, especially if we're the party commissioning the investigation, to meet with the investigating officer and make it clear to them the extent to which we require them to investigate the issues, interview staff members, and essentially test the evidence they find. So we need to make sure that the investigating officer is clear that a focused investigation, which is thorough and test evidence, is absolutely essential. One of the things I do if I'm working with somebody who is going to conduct an investigation is to ask them to make sure that when they're looking for evidence, they look for evidence that not only suggests that someone is guilty, but they look at evidence that might suggest that they're not and that something may not have taken place in the way that has been alleged, because that's really helpful in making sure that the investigating officer is keeping themselves impartial and unbiased. So I think that's a really important point to consider. So I just want to cover some things I've got on my list here. So the investigation process must be reasonable at all times. That means that you inform the employee that an investigation is taking place into their conduct or capability, whatever the issue is that you are investigating. The employee should be informed that they are under investigation. You should always adopt a reasonable time frame. So we don't want the investigation to become long and drawn out unnecessarily. Sometimes in complex matters, that isn't always possible, and the investigation process has to be extended beyond the original time frame. And if that's the case, and if you think you're going to exceed the deadlines that you've set, it's always helpful early on, as early as you can, to go back to the parties who are subject to the investigation and to inform them, to keep them updated on your progress so that they're aware of what is happening. If you've established that you need more time, give them an extended deadline and work towards that deadline with the investigation plan so that all parties are aware of what is happening. As I've said before, you need to make sure you follow your internal procedures wherever necessary. The investigation should be about establishing facts. The investigating officer is not the decision maker, so they shouldn't stray into making decisions. They are purely there to establish facts. You should avoid confirmation bias, all the things that we know as HR practitioners. And they absolutely should be mindful of confidentiality. So the investigating officer needs to be really considered in who they speak to as part of the investigation process, making sure that they inform all parties that any discussions are confidential. They should not be discussed outside of that investigation process itself. And they should make people aware that if they were found to be breaching confidentiality, the company could, if it so wished, to take formal action with the employee, because ultimately, when we're conducting an investigation, we're essentially setting out to establish what's taken place, And when we're speaking to individuals, it's really important that they know that they shouldn't be sharing this information with a wider population of the workforce. So that's something to make sure that if you're supporting someone to conduct an investigation, it's making sure they're aware that that responsibility sits with them as the investigating officer. So I'm just going to briefly touch on suspension during the investigation process. I always say in old money, so in days gone by when I first started out in HR, it was often seen if you were dealing with like a gross misconduct situation, for example, that if you didn't suspend, it could make dismissing risky to the organisation. Thinking on suspension has now changed. And actually, what we always advise our clients is you should only ever suspend if it's absolutely necessary to do so. If you suspend, an employee may try and argue that actually the suspension was punitive and it suggested that we believe they are guilty of committing an offence. And actually, we would argue that's not the case. But if you have suspended when it wasn't necessary, it can make your decision to suspend difficult to defend. So what we typically say is, if you have a good reason to do so, that should typically mean that there are health and safety concerns by allowing the person to continue working. There's a risk to the integrity of the investigation process itself. So the employee under investigation may be able to tamper with evidence or intimidate witnesses. There could be further acts of misconduct that you want to mitigate the risks of. Working relationships may have been damaged, and that may have the potential to cause issues for the business. So if you are going to suspend, what you need to do is be able to step back and just weigh up, is it necessary? Why am I thinking suspension is necessary? And I always recommend documenting your reasons. It doesn't have to be war and peace. It can just simply be a bulleted note to yourself where you document the reasons you've taken to suspend that employee. Another good alternative, and it's something that we do with clients, is I have a suspension risk assessment tool that I use. It's something I've developed over the last 10 years, where if we're weighing up whether we need to suspend someone, there's a list of core questions that we would consider, such as, are there health and safety concerns? Do we think this employee is likely to tamper with evidence? Is there evidence that suggests they may intimidate witnesses? And that could make gathering witness testimony more challenging. So we weigh up those risks to make sure that if we are suspending, we're doing it for the right reason. So I'm going to come on, and we've talked a little bit about maintaining confidentiality already. But I just want to touch on, maintaining confidentiality, but also protecting witnesses if there's a genuine need to do so. So confidentiality should be at the heart of any investigation process if we want to avoid grievances and potentially constructive dismissal claims. So that's a really important point to consider. The investigation process should be as confidential as it possibly can be, and the information should not be readily shared unless it's necessary with appropriate people. So when you're interviewing witnesses or other parties, you just need to weigh up, do I need to speak to this person? What do I need to share with them? What do they need to know for me to be able to gather the information that I'm looking for? And then just managing expectations and boundaries with everyone you speak to, that the matter is confidential. So every person that's spoken to as part of the investigation process must be told that the nature of the investigation is strictly confidential. And as I say, I always recommend saying to individuals, if you were found to be breaking that confidentiality, that may be something we would need to address with you more formally, because it's a serious matter, it's a serious issue. We need to be able to trust that people will maintain confidentiality when instructed to do so. Okay, so I just want to come on to confidentiality of witness statements. So we should treat witness statements as confidential, absolutely. We should never give an absolute guarantee of confidentiality. This is something I encounter a lot in my work, where we will be speaking to parties. I've just dealt with a really complex matter recently, where I've had to interview 18 individuals as part of an investigation for a client organisation. Some of those individuals were employees, other parties were external contractors. And people wanted, a guarantee of confidentiality as part of that process, and that, the information they shared with us would not be made available to the respondent. And what we had to do was to manage expectations really tightly around that, because the reality was I couldn't give an absolute guarantee that the information they shared with me would not be made available to the respondent, because if I had made a recommendation to the client that I believe there was a case to answer and that potentially disciplinary action was necessary, I would then be saying to them it should be referred to a disciplinary officer. In that scenario, the individual does have the right to see the information we've gathered through the investigation process that we being the employer, would be relying on at the disciplinary hearing. So it's really important not to give an absolute guarantee, because unless it's absolutely necessary, I never recommend anonymizing witness statements. The only time I ever anonymize witness statements is if someone presents to me genuine concerns that they may be at risk of retribution or harm in me sharing that information. And then on those occasions, we would give consideration to either redacting notes or minutes from meetings, or providing an anonymised witness statement. But again, we don't do that readily, and we always take into consideration the kind of concept of natural justice, where somebody, if they are being invited to a disciplinary hearing in front of a disciplinary officer, they do have the right to see the evidence that has been gathered about them or their conduct, and they have the right to be able to see what has been said about them and potentially who is saying things about them, so that they can test the evidence and raise any challenges that they want us to take into consideration as the employer. Okay. So holding investigation meetings are some things I want to just run through. I've got a little list of things for you guys to consider if you're about to embark on an investigation process. So firstly, where we as HR practitioners can add enormous value to the investigation process is making sure that the person who's been appointed as the investigating officer, it's clear what they're supposed to do. So we need to remember that typically this is going to be, in most organizations, a supervisor or a line manager who will be given the responsibility of conducting an investigation, unless you've been appointed from the HR department or HR team, where maybe you're a standalone HR practitioner. So, but typically we need to make sure, sorry, my lights have just gone out. They might come on in a minute. But we need to make sure that we are supporting whoever we appoint as the investigating officer, especially if they are a line manager or supervisor, that they are clear what they need to do and how they should go about doing it. And that's our role, giving advice and guidance on the process and the procedure that should be followed. So things to do before an investigation meeting is plan the questions which need to be asked. This is something that's really important. And actually, when I'm advising clients who are conducting their own investigations, often that's something that gets overlooked. Sometimes in haste, people gather information and they think, well, actually, I'm going to sit in front of the individual and I'll work through the paperwork or the documents that I've got, and then I'm going to ask questions as I go throughout the meeting. Actually, it's much more effective to sit down, read in on the matter that you're investigating. So if you've got documentation already available to you that is considered evidence, read in on that information and then make a plan of the questions you want to ask. We call it a question framework. So we will always, if I'm handling an investigation myself, I always build a question framework for every person that I interview. Sometimes my question framework will differ depending on who I'm speaking to. Sometimes I will be working from a general question framework where I'm interviewing a wider population of people to establish general facts that are relevant to the matter that I'm dealing with. But I never go into an investigation meeting without having done that work beforehand. So that's really important. Again, we're still on things to do before the investigation meeting. Making any logistical arrangements, really important. Writing to attendees and inviting them to an investigation meeting is good practice. There's nothing, it's not required in law that you do so. If someone is working on site, you're more than able to approach the person and say, hey, can I have a meeting with you? And you can pull them into a meeting. But I typically, because I'm working externally, I will always write to parties, inviting them to attend the meeting. And I think it's good practice to do so. Puts the person on notice that you're inviting them to attend an investigation meeting. You can give them a top line overview of what you want to talk about, but I wouldn't go into any real detail at that stage. But I would also include in my letter not only the time, the date, and the location of the meeting and who will be present, but I also cover off confidentiality. So I make it clear at that stage that what we discuss is confidential and should not be shared with anyone outside of the investigation process. So now we're moving into the start of the investigation meeting itself. So I always recommend that the investigating officer explains who's present and why, so you make those introductions. The purpose of the meeting, you're going to recap on what you put in the letter. So you'll already establish that information. You're going to set out the investigating officer's role, i.e. fact finder, not decision maker. Typically in my work, when I'm conducting an investigation, and it will be the same for you, I will be conducting an investigation to establish facts and make recommendations. So that's an important point to consider. You just bear with me. I apologise. I don't know whether you could hear that, Joe. It's just that I've got an internal phone system.
I just heard one little ring, that was all, nothing.
No, fine. I apologise. I've just muted that now, so I'm hoping that won't happen again, but I apologise to everyone. So, yeah, we've covered the investigating officer's role. Again, reiterate confidentiality. I'm banging on about that, I appreciate, but it's really important because I want to make sure that if we have any issues later on and we're challenged by the person who's subject to the investigation, I want to be able to demonstrate that I have, throughout the process, taken my responsibilities for maintaining confidentiality seriously, and that I have informed all parties that I've spoken to that the process is absolutely confidential. So that's really important if you get issues later on. You also need to make clear at this stage who will see the notes or the statements from those meetings. Really important early on. So when I'm interviewing parties, I always say to them, the information I'm gathering is going to be in the format of notes. We're going to send those notes to you. We want you to review them. We want you to sign them to say that you agree they serve as a fair reflection of what we've discussed in the meeting. But we also inform them that these notes will form evidence, and if we make a recommendation that this matter should be referred to a disciplinary officer, those notes will be put in a bundle and made available to the respondent. And at that point, that gives the person the opportunity to raise any concerns they may have about you sharing that information with the individual concerned. And you can take note of that, and you can then make an informed decision about how you're going to handle that moving forward. Just to reiterate, as I said earlier, I do not readily anonymise witness statements unless there is a genuine reason to believe that the concerns being raised are legitimate. So just bear that in mind. It's also worth pointing out as well that at the end of the process, so once you've concluded your investigation, you're going to be drafting an investigation outcome report, and it's worth mentioning to the parties you're interviewing that the evidence you've gathered, so the notes from them, the investigation meetings held with them, any comments they may have made that's relevant to the investigation process itself, you may be referencing that or referring to that in your investigation outcome report. So just, again, bear that in mind and make sure that we're upfront with everybody at that stage, because it avoids issues later on. So during the investigation meeting, questions should be asked which are focused on getting facts. Remember, this is all about fact finding. They should probe, but not in an aggressive or adversarial manner, which could make the attendee feel threatened or intimidated, and then therefore defensive. And that's going to impact then the quality of the evidence that you're able to gather as part of your investigation process. If the attendee refuses to answer questions, make a note of that. I sometimes challenge, not in an aggressive way, but I may challenge or explore why do you feel unable to answer that question. But ultimately, I can't force someone to answer a question that they don't want to answer. So if they absolutely refuse, you make a note of that, and hopefully they'll give an explanation as to why. I've had it where people say, no, I'm not prepared to answer the question. So again, just note that in your records before you move on. And I've touched on this already, but you should also be looking for opportunities during the investigation meeting to find evidence which can substantiate what is being said. So that's another important point. And then just moving to the end of the investigation meeting. So again, I always recommend when I work with my clients that they ask the person they're interviewing if they have anything to add or that they feel is important to mention for the investigation process. I always cover that off at the end. I go in with a little checklist. I'm not sure what you guys do, but I always have a checklist that I follow. So as I'm going through my investigation meeting, I'm actually ticking off the questions I've asked, and I'm also ticking off things like, have I said, is there anything else you want to add at the end? You should ask the attendee if there are any other people they think that you should be interviewing as part of the investigation process. And if they do make a recommendation that there's someone they think is helpful for you to speak to, just ask them why, so we can establish whether it's necessary to go and speak to additional parties, because not only does that take up time and resource, but it also could impact on confidentiality. We want to minimise the amount of people that we need to speak to. That being said, there's a genuine need to speak to a wider population of people. There's nothing wrong with that, because ultimately your job as an investigating officer is to establish facts and to gather as much evidence as you can to support your position in terms of your findings. Okay. You should explain that you may need to arrange a follow-up investigation meeting. That's often helpful. Again, I do this as just a matter of good practice. So I will say to the individual, thank you for attending the meeting. Thank you for sharing the relevant information with me. I may need to speak to you again as part of the process. And if I do need to do so, I will contact you. So again, it just puts them on notice that you may need to make contact with them again, and also explain that they will receive a copy of the notes from your meeting. So I always make it clear that, you know, I'm going to send you these notes. I'm going to ask you to review them, and I'm going to ask you to confirm that you're happy they serve as a fair reflection of what was discussed during the meeting. Now, when I'm handling investigation meetings or investigation work for grievances, for example, I, as a matter of routine, record all of my investigation meetings. This was at one point considered quite controversial, because it may be that you have a line manager that says something that's unhelpful or maybe not appropriate to the investigation, and you know, employment lawyers would often be concerned that that information is then recorded. However, I go in with the viewpoint that if I'm not recording, the employee may be recording. Given the rise of, you know, smartphones and recording devices, I've experienced it where employees do take a covert recording. So for me, when I'm conducting my investigation work, I record the meetings. It's disclosed to all parties present. And what we always say is that we're recording the meeting to aid good record keeping. And then what we do is, from those recordings, we type or prepare a typed transcript. What I found over the years is actually by recording the meetings in that way and preparing a typed transcript, we avoid all the unnecessary toing and froing over trying to get handwritten notes, which have then been typed up, agreed with the relevant parties, because people start to say, you've missed information, you've misinterpreted what I've said, and so on. So it can be very helpful. But if you are going to record your meetings, absolutely inform all parties present, the meeting's going to be recorded, absolutely advise them that it's to aid good record keeping. And what I personally do is I say to the individuals, once we've agreed the transcript, once we both parties, so myself as the chairperson, the note taker, and then the individual interviewed, once we've all agreed the transcript is a fair reflection of our discussion, we will delete the recording. The only time I retain a copy of the recording is if the party being interviewed says, I would like a copy. So that's something else that we do as part of our investigation work. That being said, I work with lots of clients that don't record those types of meetings. And if you're not going to record your meetings, then obviously you need to make sure that you have a note taker present who is able to take a decent set of notes which provide a fair reflection of your discussion points. It doesn't have to be a verbatim record, obviously, but it's important the notes provide a fair reflection. And it's also worth, if you're not recording, making it clear that you yourself are not recording the meeting and that you do not give your permission for the meeting to be recorded. So you should ask the individual you're interviewing, can you please confirm that you're not taking a recording of this meeting? And that should be documented in your notes. Okay, so just quickly move on to things to cover during the investigation meeting. So we're going to look at just questions, really, and this is a really important point when you're handling an investigation process yourself. So make sure you make good use of a range of questioning techniques. So open questions, which we all know, they're really helpful to gather information. Closed questions, when you want answers to specific questions or you're looking for specific information. Closed questions can be quite helpful in that regard. Probing questions to test evidence, but as I always say, in testing evidence, make sure that you don't come across as aggressive. Feeling questions, so not always necessary, but some good examples could include, what concerned you about Jane Doe's behaviour? Why did you feel that you had to step in and intervene? They're good feeling questions that could help elicit information that you want to gather as part of your investigation process. With me. What else questions? So these are to make sure that you have all the relevant information. So, do you remember anything else about the way Jane Doe was behaving that morning? That's a good what else question. And is there anything else you think I need to know? So that's another good example. And then summarize at the end. So make sure you always end an investigation meeting with a summary or a roundup of what you've been told to make sure that you have properly understood the information that you have gathered during that meeting. So, and then we move on to preparing the investigation report. So I just want to talk about this in a bit more detail because in my work over the last 20 years, I've seen a mixed bag in terms of reports or documentation that confirms the outcome of an investigation. So if the investigating officer has been asked to make recommendations, and they should do so on the following basis, and this is really important. So it should be the one, formal action, i.e. a disciplinary hearing, two, informal action, i.e. mediation or further training, or number three, no further action. So that's really important. You limit your recommendations to those three areas. So you'll see in any reports that I provide, if I believe that there's a case to answer, I say to the client in my report, I believe there is a case to answer. They understand why, because I summarise that based on the evidence I've gathered, and I simply recommend that the matter is referred to a disciplinary officer. I do not talk about sanction, I do not talk about outcomes, because that's not the remit of my role. My role is to establish facts, make a recommendation, and then it's up to the client, or if you're working internally, it'll be up to whoever is appointed as the disciplinary officer. So that's an important point to remember. The investigation report should be clear and concise and also objective, and that's really important. It should be objective when setting out the facts and findings from the work that you've undertaken during that process. So I have got a little list again that I've gathered. So these are some tips from ACAS, which are really helpful. So you should avoid the use of nicknames or any jargon. So for me, for example, when I'm writing my outcome report, it's normal for me to refer to Mr. Doe, Mrs. Doe. So it sets a level of, I guess, impartiality really, and a level of formality. So I never use nicknames. I certainly always try and avoid jargon as best I can. You should always use simple and appropriate language. So simplify things as best we can, make sure it's easy to understand. Stick to the facts always, that's really important. Always stick to the facts. If you're arriving at a conclusion or you've got a particular viewpoint, make sure you refer back to the evidence you've gathered. So when I do my investigation work, I gather evidence, I create a coded document bundle, and then from my coded document bundle, when I'm putting everything together and I'm drafting my outcome report, I will refer to the coded bundle. So I will say, please see page 2, power 6 of document D36, for example. So I'll always refer back to the evidence I've gathered when I'm setting out a particular viewpoint, because what I'm doing is demonstrating I have this viewpoint because it's based on the evidence I've gathered. And also that allows the person who's subject to the investigation to see how I've arrived at my findings or conclusions, and they can challenge that and they can make their own representations should the matter be referred to a disciplinary hearing. So that's an important point to consider. Always include all evidence collected. So I include all evidence collected in an appendices at the back of my report. I don't necessarily refer to every single piece of evidence if it's not relevant to supporting my, findings, conclusions, etc. But I list all evidence that I've gathered throughout the investigation process, and it's coded and it's put into the appendices of my report. And then I also store it in a coded document bundle, which I then send on, in my case, to the client. You would be sending that on potentially to whoever's going to be appointed as a disciplinary officer if you find there's a case to answer and that the matter should be referred to a disciplinary hearing. If you're going to use acronyms, again, we will say try and avoid using acronyms, but if you're going to use acronyms, explain what they are so that people are aware as they're reading your report. Again, this is very basic, very top level, but a good investigation report should be structured with an introduction, an outline of the investigation process. And what I mean by that is in my reports, which are fairly substantive documents, but I will always set out the investigation process and I will say what I've done as part of the investigation process. So, when I'm writing that report, I always have in mind that I'm telling a story. I want to know if this matter went to an employment tribunal and an employment judge, picked up my report, they could read that from start to finish, and they will understand why we were investigating. They'll understand the process that I followed as part of the investigation. Who did I speak to? What evidence did I review, etc. So they can see, okay, that's the process. You should always set out in your report your findings. There should be a clear section that is assigned for findings, and in that section, you set out those findings clearly in a way that's concise and easy to understand. You should then have a conclusion, and you should also have recommendations. In my reports, I'm going to say they're a little bit more substantial. I'm just giving you a basic framework, but I also have a section for any mitigating factors that may have been put forward that I want. If I'm recommending the matter goes to a disciplinary officer and someone's made, they presented some mitigating factors, I record those and capture them, and I make the chairperson of the disciplinary hearing aware. So when they get that report, I've captured that information, and it's easy for them to review and take into consideration. And then obviously my section at the end for recommendations. That's the most important section, is being really clear on what you're recommending. Nobody reading that report should be unclear about your recommendations. So you need to set that out in a way that is clear, concise, and easy to understand. And that brings us to the end of the webinar. Just before we go into questions, just want to briefly introduce my team. So I work alongside Michelle Kemp, who's the partner and head of employment at the firm, along with my colleagues Chris Dobbs, who's one of our employment solicitors, and Kate Fretton, who's an employment solicitor, but a consultant solicitor with our firm. So that is our team. I'm going to hand over to you, Joe, for questions. I don't know if any come in.
Some good questions come through. So Anna has asked, first of all, what are examples of terms of reference?
So terms of reference really set out what it is you've been asked to investigate. So when I'm establishing my terms of reference with a client, I will say to them, what's the issue? So what's the matter that we're dealing with? Is it a conduct issue? Is it a capability issue? Is it because a grievance has been raised that we're now conducting the investigation? And then I will explain in some detail in my terms of reference what that matter is as I understand it. And so then I will say, this is the issue, this is how it's come about, this is what I've been asked to do. So I capture what the client has said to me they want me to go away and investigate. And then I will also capture any people that have been, and so any names of individuals that have been identified to me by the client. I capture all that information within my terms of reference, so that when I agree with the client, and if you're internal, it's when you're agreeing with any relevant line manager what the issues are and what you need to go away and do, because then you're all clear on what the investigation process needs to look like. So that's why I'm a big advocate of get your terms of reference kind of set out clearly at the front end of any investigation work. I hope that answers your question.
You might have answered part of this one, Nathan. So Andy asked, they're particularly interested in who should conduct the investigation. For example, is it appropriate for the manager of the alleged offender to carry out the investigation, bearing in mind that the manager may also be questioning other team members?
Yeah, I mean, it's not inappropriate for the line manager to conduct any investigation. The only caveat I'd put on that is whether they're involved themselves. So if they've got any involvement in the complaints that have been made, so for example, if you've got a grievance that's been raised and the line manager has been named in that grievance, then it wouldn't be appropriate for them to investigate. But if the line manager has got no involvement in the issues or matter at hand, then there's no reason why they shouldn't investigate. I mean, typically I would say that that would be appropriate if you've got the management infrastructure to allow them to investigate as the investigating officer, and that matter could be passed to another manager to chair any subsequent disciplinary process. If there's a case to answer, then there's not an issue. I work with some clients who they normally will get a manager who's not the line manager to conduct the investigation, and then leave the line manager of the employee to chair any subsequent disciplinary hearings. I've got clients working that way. But as I say, each case is different. And if you've got anybody that's been identified or named as part of a complaint that's given rise to the investigation, they shouldn't be conducting that investigation, because essentially they're involved and they could potentially be investigating themselves. That's just an important point to remember.
Okay, so Myra's asked, what happens if the terms of reference change throughout the process? You mentioned a number of people need to be interviewed, but as you're investigating and you find out that more people need to be interviewed.
That's a great question, and actually that happens a lot in my work. It's just happened recently. So the investigation that I was referring to early on, where I ended up having to interview 18 individuals, and that was a particularly complicated matter. Um, and what we had to do is to manage the terms of reference on a almost like a week by week basis. So as we interview parties and more information, was made available to me, I was then able to establish a list of additional parties that I felt we needed to speak to. And then for me, because I'm working externally with clients, I go back to the person who's commissioned the investigation, so the person that's giving me instructions, and I say to them, hey, the terms of reference at the start of this process was X, Y, and Z. Unfortunately, as we've started the investigation work, we've established or identified additional information or additional parties that we now need to speak to, and that's actually going to take us more time. And in the case for my clients, potentially cost. But for yourselves, if you're internal, it's going to take you more time and resource and it's going to extend the deadline, the timelines around your investigation. So what I do is the moment I know there's going to be, and I'm going to need to amend my terms of reference or the scope of the investigation, I go and speak to the relevant parties, get everyone around the table, and we agree on a way forward. So that's, when you're internal, it's probably less of an issue, but it's still really good practice just to keep all stakeholders, updated as necessary. I hope that answers your question.
Danny's asked, do you have an investigation plan template?
I mean, we have one that we use internally as for us as a team. I believe, off the top of my head, that there is a really useful one on the ACAS website. Um, so that can be really helpful. I mean, ACAS has got some really useful tools and guides. And I always say to organisations who are maybe just wanting me to help advise and guide, which we do, that actually some of the ACAS tools and documentation templates they have are really helpful. So there is a good investigation plan on the ACAS website. I hope that answers that one for you.
Thank you. Patsy's asked, should the investigator present their case at a hearing? My organisation's practice is for them not to attend.
Yeah, and that is normal. I mean, it depends on how your organisation works. So, look, public sector organisations, I've got public sector clients who I've done work for where there's an expectation that if you've done an investigation, you will present at the hearing. That's not typical, certainly not in commercial organisations, but it's not unheard of, and there's certainly nothing wrong in doing that. But typically, if that's a practice or a process that an organisation follows, they normally have that set out in their disciplinary policy or procedure. So I always work to on a basis of I may be called to present in person, and that's not an issue because once you've done the investigation, you're so familiar with the content and your findings and your report that giving evidence in person at a hearing is not an issue. But yeah, typically I've done it a handful of times in my career, and actually it's only been when I was as a consultant in my own business, and latterly now at Frettons where I work now, and it's always been public sector. So it doesn't, that's not to say it's always, but predominantly when I've ever had to do that in person, it's because it's a public sector organisation, and that's the framework that they follow.
Thank you. Andy, you've asked another question, which I think we've covered. If we haven't answered that, will you just pop a note on? Karen has asked, would it affect the investigation should the questions framework wholly differ per investigation meeting? I've always tried to keep the questions the same where practical.
Yeah, absolutely. I mean, I say when I said that the questions will vary depending on who you speak to, that may be the case because it depends on where the individual works. They might work in a different department where, all of the questions you've asked other parties aren't relevant. It might be you're going to ask some very specific questions, but generally speaking, if you're looking to establish facts, yeah, you should be asked. There should be a common theme to your questions. So to give you an example, the investigation I just referred to with my 18, witnesses, there were a large population of that pool of people we spoke to were asked the same questions. Some individuals will ask slightly different questions depending on where they worked, whether they were internal or external, for example. But there was a common theme, and I could always justify why I've asked specific questions because I was looking for specific information that maybe had been made available to me from a previous investigation meeting that I could then draw on. So, yeah, by and large, you should be asking consistent questions that are focused on establishing the facts. If you're dealing with a straightforward matter, um, that shouldn't be too much of an issue. But yeah, absolutely, I would always say you shouldn't be going in asking wildly different questions because that's actually unhelpful. You just need to be focused on what, I always say to my clients, what's the issue? So what's taking place that we're not happy about? That should be our focus point. We shouldn't be widening the net. We want to avoid doing that because what you don't want to be seen to be doing is conducting a witch hunt or going on a fishing expedition. And I've seen that happen in practice, and that could leave you exposed to challenge over the strength of any allegations or complaints that you're investigating against an individual, specifically if you're going to rely on making a decision, relying on that information or those complaints to make a decision about whether you terminate employment. So I always say stick to the facts really closely, avoid going on a fishing expedition because it could cause issues later on. I hope that answers your question.
Jasmine has asked, the note taker is often a member of the HR team. What
Mhm.
is your opinion on the note taker asking a question to clarify a point if they feel the investigating officer has missed something?
Yeah, I mean, I don't lose sleep over that. I think it's normally more appropriate if they're asking for clarification to check their own understanding for record keeping. Ultimately, it is for the investigating officer to make a decision about what they do and don't ask. And one thing I typically would say is, for example, if I'm in an investigation meeting, certainly when I was in my own firm, I had a PA that worked with me, and she was marvelous. It's made my life so much easier. But what she got to know is that if I didn't ask a particular question, there might have been a reason for it. So what I would say is, if you've got a note taker, it might be that you think about setting the parameters for their role and saying, look, if they feel at the end of the investigation meeting you've not asked a particular question or you may have missed something, they could cover that with you at the end, and then you could always go back to that individual and say, when we met, I didn't ask you X, Y, or Z, and I just want to cover that information with you now. You could do that by email. You could invite them back to another investigation meeting. So I have never got an issue with the note taker saying, "Can I just clarify for the notes?" But yeah, I would maybe advise caution around allowing a note taker to be stepping in and asking questions that they feel you should have asked but haven't. Because remember, you're the investigating officer. They're purely there to take a record of the meeting.
Kate's asked, what happens if they decline to be recorded? Do you still have to state you'll record at the beginning of the process?
Yeah, I mean, I make it clear that our process as the meeting is going to be recorded, and I explain the reason why. So it's not a covert recording. They understand that if someone's particularly bothered by that, you could opt for just taking handwritten notes in the usual way, or maybe someone's typing directly onto a laptop. But if they're going to make an issue about you recording, I think you need to be clear that you're going to take an accurate record of the meeting, but it won't be as accurate as if the meeting had been recorded. Because ultimately, when you have a recording, you're going to produce a really accurate transcript. So I push back. People say to me, I don't want the meeting to be recorded. I ask the question why, because what I say to them is, look, I think it's in your interest to record the meeting because it's going to aid us in capturing a really accurate record of what's discussed, and we're not going to have this issue around things being misunderstood or misinterpreted, for example. So that's my viewpoint. But yeah, I always make it clear at the outset the meeting's recorded, and this is why. And if you agree the notes and they don't want a copy of the recording, you'll permanently delete it, because once you've agreed that transcript, you can permanently delete the recording. I don't work from them. I'll only ever work from a transcript.
Okay. When there's a translator present in the meeting, does the translator need to sign the meeting notes in addition to others?
Yeah, I think if you've had somebody present, it's a bit like if someone chooses. Now, obviously, at an investigation meeting, as most of us will know, there's no right for the individual to be accompanied. I mean, though often I allow it, I haven't got an issue even though it's an investigation meeting. Someone says, I want someone to accompany me. I haven't got a problem with it. But if somebody does accompany a witness, or if I'm chairing a disciplinary hearing, for example, I will always get all parties who attended to sign the notes to say that they're a fair reflection of what was discussed. So that's good practice.
Samantha's asked if someone raises a grievance during the investigation process, should the investigation process halt until after the grievance has been heard?
So I'm guessing you're asking that question if the investigation is relating to a disciplinary matter. So there's no hard and fast rule. It really depends on the circumstances. Now, what I would say is if you're investigating a disciplinary matter, a misconduct issue, for example, where allegations have been made, and then the person subject to that investigation raises a grievance, it may be appropriate that you would suspend the disciplinary investigation that you're undertaking whilst you look at the grievance. It may be, depending on the circumstances, that you can run both simultaneously together. So it is, I know I'm going to sound like a politician, it really depends on the circumstances of what you're dealing with at that time. So what I always say to our clients is that if during an investigation for allegations around misconduct, for example, the respondent raises a grievance, depending on what's been raised, you might want to consider putting that on hold and investigating the grievance because it could actually impact the outcome of the disciplinary process if you're going to recommend that disciplinary action is taken, of course. I hope that answers your question.
Chloe's just asked if you could share more about what you mean by coding the evidence.
Oh yes, so it's a process. I mean, it won't be unique to me, I'm sure. It's a process I've developed myself. It's very basic. So when I gather evidence, certainly in the form of documentation, emails, policies, might be data sheets, letters, for example. I mean, I've got a case, an investigation I'm working on now for a client where the bundle of documentation or evidence they've sent me, I think it is, we've got 60 documents so far. So essentially, I go through, put that documentation in date order. I then create a log of all the evidence. I summarize what that evidence is, what it tells me. I summarize whether it supports allegations made, whether it suggests that actually the allegations made don't have merit to them. And then what I do is I code them. And so the very first document in date order is document 1, so it's D1. And I've had matters where my coding goes all the way up to D150. So it's a way of me stripping out all the titles of the documentation or put them in date order. It's a really straightforward way of saying D1 is this, and if I'm referring to it in my report, we can go back to that document very easily, and so can my client ultimately. So when I'm writing my report and I'm saying, I'm taking a summary of a statement made by someone during an investigation meeting, I can say that set of notes was D51, and the client can go to D51 on the relevant page to the relevant paragraph and see what I'm looking at, so they can see it with their own eyes and make their own judgment about whether they agree with my viewpoint or not. So I hope that answers the question. Very basic, but it saves you huge amounts of time at the end, especially if you're recommending something should go to a disciplinary hearing.
Danielle's asked, who should the investigating officer be and who should chair and decide the outcome of the disciplinary hearing? Could it be a line manager for all three if there's a performance concern?
Well, no, what I would always say is if you have the management infrastructure, so if you have more than one line manager, and if you're in an organization that has 20 plus people, you're likely to have at least 2 or 3 members of a management team. Then what I would suggest is you have one person who does the investigation and you have another person who chairs the disciplinary hearing if the investigating officer recommends that the matter is referred to a disciplinary officer for consideration. And the reason we say that, and I know we all know this, is that what you don't want in an ideal world is to have the chairperson of the disciplinary hearing having been involved in the investigation process, because ultimately the employee should be able to attend a disciplinary hearing knowing that they're meeting with someone who's impartial, they've not been involved before, that they are a fresh pair of eyes, and that they're going to have access to a fair hearing where no predetermined outcome has already been decided. Because it can be very easy when you've done an investigation and you've looked at evidence and you've established the facts and you've made a recommendation that the matter should go to a disciplinary hearing, you've got in your own mind at that stage, I know certainly I do, once I make that recommendation, the report goes off, that, whether I think, not that I ever share this, because it's not my place to share it, but at the end of the investigation, you might think, well, actually, that person probably should be dismissed or have some kind of sanction because I've looked at the evidence and I can see what the evidence has told me, but ultimately it isn't for us to be telling anybody what the outcome should be. That's not the remit of our role. So that's why it's really helpful and important that we try and separate out um, that those two processes. Now, the one thing I would say is in small organisations, and I've worked with lots of small organisations, they don't often have the management infrastructure, and sometimes it's just not possible to do that. And you may find that the person who's done the investigation may have to be the person that does the disciplinary or chairs the disciplinary process. And again, if that's the case, you just have to think about how can you keep the process as clean and as impartial as possible. Now, one thing to consider, and I say this to client organisations, is it can often be preferable that you instruct an external HR consultant or firms such as Fretton's, where you have access to someone like me. You won't get an employment solicitor doing it because if an employment solicitor has to represent you later on in legal proceedings, they can't be in a position where they become a witness. Where my role comes in as head of HR services, I can conduct all of those services for our clients because I'm not going to be representing them in the tribunal. So, it's always worth considering, and I say this to client organisations. I know when they're smaller, people often think about resources and cash, but it can often be really helpful to instruct an independent consultant to come in and share either investigation or potentially disciplinary hearing. So, anyway, I shall get off my soapbox on that one.
Nathan, I'm just conscious of time. Because
I've
there's
got
quite
time.
a few more questions. Are you okay?
Yeah, of course.
Okay. Leslie's asked if can an employee refuse to attend the office whilst a grievance investigation is being held? We can see no reason for them to make such a request.
No, I think you need to, again, on a case by case basis, I would want to understand why you're refusing to attend work. Absolutely. If they've got concerns about working relationships or their terms and conditions, whatever the case may be, that's brought about them raising a grievance, unless there's a valid reason for them not to attend work, I would say to them, no, they're expected to come into work.
Okay.
That's my view. But absolutely, take into consideration any viewpoints they make. So if they start talking about, they're fearful because they've been bullied, it's having a detrimental effect on their mental health. Take that into consideration. You might want to think about what can we do that facilitates them coming to work, but maybe avoids them having to have contact with the person they made complaints about. But I wouldn't be in a hurry to say to somebody, yeah, you don't have to come to work while we're conducting the investigation.
David's asked if during an investigation there's a potential criminal act identified, can you recommend how to balance the criminal versus employment law considerations?
Yeah, I mean, this is a good point. So again, and I've dealt with this many times over, where I've been instructed to conduct an investigation, and then the police become involved. And I've dealt with a case a few years ago now where there were allegations of someone accessing pornographic material involving children, and the police did become involved in that matter. And it's an interesting point because there is a general viewpoint that if the police are conducting an investigation, the employer should put on hold any investigation so as not to potentially damage the integrity of any police investigation. What I always say is take advice if you're in a situation where you're dealing with a matter, it's clearly potentially serious if the police are involved. And the reason I say take advice, and that's taking advice from a firm such as us, Threatens, or maybe an independent HR consultant, if you're a business owner on this webinar today and you haven't got access to an internal HR team, speak to somebody external. So it could be an HR consultant, it could be a firm such as us, and talk to them about the situation you're dealing with. Now, my viewpoint is always I will treat things on a case by case basis, but typically it's not going to be reasonable for you to delay conducting your own investigation whilst you wait for the police to conclude theirs. And the reason I say that is because a police investigation could, depending on the circumstances, could take place over many, many months. And so the matter I've just referred to, where around the pornographic material involving children, that investigation process was likely to take between 9 and 12 months, according to the police force who were investigating at that time. The reality was the organisation had concerns raised by employees who had become aware of the allegations made against this employee, and this employee could potentially come across children within the organisation. So we had to make a decision around, do we hold off while the police investigate and suspend this person? And we considered that not to be reasonable, because we don't want someone on suspended or full pay for a 9 to 12 month period. And so we proceeded with our own internal investigation. And we were, we made parties aware that when we were conducting that investigation, it may be that we would be asked to release that information to the police, so everybody was aware. But we did proceed with our own investigation because it wasn't seen to be reasonable for us to delay proceedings. An ACAS will always say that if you're going to investigate concerns around an employee's conduct, capability, whatever the case may be, there shouldn't be any unnecessary delay in doing so. So again, I think it's important that you take each case into consideration on an individual basis, but I wouldn't just have a blanket approach of no, we delay. And the reason I say that as well is we need to be mindful that an internal workplace investigation is a civil matter. An investigation the police is conducting will be because it's a criminal matter, and the burdens of proof are very different. So I'm sure most of you know that the burdens of proof that apply to a workplace investigation is based on the balance of probabilities. And what I mean by that is that it's more likely than not that something has taken place. And that could be, if you want to, if you look at, a situation where you find it 51% more likely than not that something has occurred, then that is sufficient for you to, take appropriate steps to resolve that situation. But obviously, as we know in a criminal law, in criminal law proceedings, the burden of proof is beyond all reasonable doubt. So it's very different. So if you've got a situation where the police are involved, definitely take advice.
Claire's asked, would you do things differently for a whistleblowing case?
I'm not sure in terms of when you say differently, but I mean, if someone has blown the whistle, then yes, we take each case, each investigation on its own merits, essentially. So depending on what I'm investigating will shape how I proceed with conducting that investigation. Now, for example, if someone has blown the whistle, there might be concerns around protecting their identity, making sure that they don't face retribution for raising concerns or any victimization issues. So, if someone has blown the whistle, then absolutely we would look at that case in isolation and go, right, what's the issues that have been raised? What do we need to investigate? Do we need to take into consideration, anonymity, for example? So those are things I would look at. But again, it's always a case by case basis, which I know doesn't give you a solid answer, but it's the best I can do today.
Danielle's asked, what happens if the person who raised a grievance isn't happy with the investigation, i.e. they disagree with the recommended outcome? And if the outcome is a sanction, such as a written warning or final written, should the person who raised a grievance be privy to the outcome?
So just read that back to me, Joe, just to make sure I understand. So it sounds like...
So what happens if the person who raised the grievance isn't happy with the investigation, i.e. they disagree with the outcome?
Yes.
And if the outcome is a sanction, such as written or final written, should the person who raised the grievance be privy to that outcome?
I got you. I missed one bit of that, so I've got you now. Yeah. So look, here's the thing. If the person who raised a grievance, once you've conducted your investigation, essentially what you're then going to do is you're going to write to them and you're going to say to them, we've investigated your grievance. Here's the findings. And essentially, this is what we've done. So it may be that you say, I'm going to uphold your grievance in full or in parts, the case may be. It may be you say that we're not upholding your grievance at all because there was insufficient evidence to support the claims made. So at that juncture, when you write and confirm the outcome to the individual who's raised the grievance, they have the right to appeal, and they can appeal in writing and set out the grounds for their appeal, which you can then refer on to an appeal officer for them to take that into consideration. If, as a result of the grievance, the outcome is that the respondent is referred to a disciplinary hearing, and the sanction is written warning, final written warning, whatever the case may be, then what I wouldn't be doing is sharing with the person who raised the grievance any decisions that you or sanctions you've issued to the respondent. And the reason I say that is because it's actually confidential between the employer and the employee subject to the disciplinary action. The person raising the grievance doesn't need to know what that outcome is. You can say to them that these are our findings, we uphold your grievance, and the matter is going to be addressed formally with the individual concerned. And there ends your responsibility to communicate any further information to the person raising the complaint. I hope that was that question as well.
Sorry, I'm just scrolling down to see how many more questions there. Bear with me a second. Okay. Sorry.
Don't worry.
Okay, if statements have been gathered and signed, would you always include the notes from the fact finding too?
On the fact finding, I mean, they're normally one and the same thing. Whoever's asked that question, just elaborate a little bit. Are you talking about handwritten notes, for example, as you work through the process? I mean, typically, it might answer your question. Any evidence that I have gathered and that I'm relying on is included. So it might be that you might want to use your contemporaneous, records such as handwritten notes, for example. But I say, if I've included a typed transcript from a meeting, then I've said don't take handwritten notes. If you are, I mean, the one thing I would mention is that if you are preparing notes, typing notes from notes taken by hand, then whilst I wouldn't make available the handwritten, I would retain the handwritten notes. So if we do anything by hand, then the handwritten notes are retained. I scan them, keep them electronically. So if anyone said, well, actually, I want to see the handwritten notes to see whether they align with the typed transcript, then yes, I would make sure you have them available. But obviously, if you've recorded the meeting, that won't be necessary.
Deborah's asked, do you share the questions that will be asked with the person in advance of the meeting?
No, no, I don't want. I mean, for me, I don't want people to go into those meetings polished or prepared. I want to ask the questions in real time and capture their responses. As I'm asking the questions.
Leslie's asked a question, but then she's had to leave. So she's then put another note to say she's hoping it'll still be asked.
Oh, sorry, Leslie.
So she's just put, oh God, I've lost it. Sorry. If the outcome of any grievance is no further action, how long should documentation relating to the grievance stay on file?
I mean, that's a good question. I mean, I would always say, absolutely check your data protection policies, your GDPR policies, because it should cover retention. You certainly, obviously, if a complaint's been made and yes, there's no action to be taken, you could put it on the personal file, which is what I do, and I would keep it for whatever time period you have within your own organisation for retaining personnel information. But you wouldn't rely on it. I know there's some organisations that will say, it should be destroyed or removed. And I've had conversations where people say, well, actually, written warnings, for example, if a written warning has expired, should we go back onto the personnel file and delete and remove it? Well, actually, in my view, is no. It forms part of the history. It's not history you're going to take into consideration, later on, if, for example, a warning has expired. A bit like if you've conducted an investigation and you found that there's no case to answer, I would suggest you'd want to keep record of that because it showcases and demonstrates that what you did. So from the perspective of the person raising the complaint, you've got evidence that goes, actually, no, we did deal with that. Should they raise any claims later on? But it also allows you to refer back to those records should you be challenged from the respondent, for example. So I would keep them. My viewpoint is I would keep those in line with your data retention policy.
Okay.
Keep
There's
them yourself.
no further questions, Nathan. I think quite a few people have had to drop off. So I'll just do the clause if that's okay with yourself.
Thank you.
So as we have said in the chats, I will send out some correspondence to everyone that signed up for the event later today, and I'll put a post on LinkedIn. So if you want a copy of the slides and or the recording, then please put a comment against the LinkedIn post. Our next event is next Thursday, the 21st of November at 12:30, and is called Critical Thinking Skills. We're also running another event from our sister company, FD Recruit, on the 27th of November at 1 p.m. about developing leaders. So links to sign up for those will be included in the email. If anyone's recruiting, we've also got accountancy recruit, FD recruit, and exec recruit in the group. But otherwise, I'd just like to say a massive thanks to Nathan for your time and putting everything together. And thanks to everybody for asking all the questions. You've made it a really good session. So thanks very much.